Yeah, I'm trying to turn it on. Do we just click in the box to activate it? How does that work?
Well, you should have an icon on your computer that says stop and start video. And if it's on, as if should be, there you are.
Just found it. Okay, sorry about that.
No problem. Thank you. Welcome to the First District Court of Appeals. We have one case on for argument this morning. We have 4 cases on our docket. Let me just quickly run through the docket, the full docket. The first case, and that is the case to be argued, is State of Ohio versus Hernandez. Also on the docket this morning is In Re CA Children. That has been submitted. Also is Bool Chand versus Bool Chand. That has been submitted. And finally, In Re SG, that has also been submitted. Counsel for State versus Hernandez, are you both ready to proceed? And Ms. Lockhart, if you will introduce yourself and indicate your readiness to proceed.
Good morning, Your Honor. My name is Sarah Larcade. I represent Mr. Hernandez in this case, the defendant appellant, and I am ready to proceed.
Thank you.
Mr. Cummins? For the state, Your Honor, ready to proceed.
All right. Ms. Larcade, would you like to reserve any time of your 15 minutes this morning?
Yes, Your Honor, if I could reserve 3 minutes.
All right, and anytime you're ready, you may begin.
Okay. May it please the court. The law in this case is settled by statute, ORC 2943-031, by this court's precedent in State v. Yanez, and by the Supreme Court's precedent in State v. Francis. In 1989, the General Assembly recognized the severity of the consequences that non-citizens face upon conviction of any offense in the state of Ohio. And our legislature determined that if any non-citizen is accused of any offense, trial courts cannot accept a plea unless they first personally address the non-citizen defendant and give him a warning regarding the possible immigration consequences of conviction. The statute provides that prior to accepting a plea, the court shall address the defendant personally, provide the advisement, which is written in the statute, and determine that the defendant understands the advisement. Indeed, the Ohio Supreme Court has made clear that the court's obligation to give this advisement is an integral part of Criminal Rule 11's requirement to ensure that a plea is made knowingly and voluntarily. If the court does not personally address a non-citizen defendant and give the required advisal and determine that that defendant understands the advisal, the court cannot accept a plea. And without such a personal exchange, the court cannot determine that the non-citizen defendant understands the consequences of the conviction that will result from his plea of guilty or no contest. And the statute goes further. Subsection D guarantees a remedy. And it provides, upon the motion of the defendant, the court shall set aside the judgment and permit the defendant to withdraw his plea if, after the effective date of the statute, the court has failed to provide the advisement. Now, there are 4 requirements in the statute that a defendant must show before the trial court is obligated to allow the defendant to withdraw his plea and vacate the judgment. Those 4 requirements are that the defendant show the warning was not given, that the warning was required, that the defendant is not a citizen, and the court at least was on notice of that, or the defendant did not say he was a citizen, and the defendant show that conviction would lead to possible deportation. Now, the state concedes that all 4 elements are met in this case. So the statute is clear. When all 4 elements are met, trial courts shall set aside the judgment and allow a defendant to withdraw his guilty plea. There are no exceptions.
But despite the statutory language that you're referring to, didn't the Ohio Supreme Court in Francis somehow read into the statute another requirement that the motion to withdraw the guilty plea be timely? And so despite the fact that it seems that the state has conceded that all 4 factors have been met per the statute, we still need to address this timeliness issue, don't we?
No, Your Honor, the court does not and should not consider timeliness or prejudice to the state when no warning was given. The State v. Francis involved some kind of warning and not the verbatim recitation of the advisement in the statute.
Well, can I just stop you right there before you explain to me why State v. Francis doesn't apply? But my understanding that is with regard to the warning, this court and Francis has said that substantial compliance is sufficient. So my understanding is that if you give some warning, you have substantially complied with the statute, right?
Yes, I would agree with that.
And so then wouldn't the analysis at that point just end? Because if there was substantial compliance, then the defendant hasn't shown these 4 factors are met. And so then we're done with the analysis. Timeliness wouldn't even become a factor, right?
I think it does become a factor because, again, the statute requires the advisement and that the court ensure the defendant understand the advisement. So if there is some substantial compliance with the statute, that is when the trial court's discretion kicks in to determine whether those 4 factors are met and whether to grant or deny the motion.
Let me ask you, ma'am, concerning the substantial compliance, what I found interesting about this case is both the defense attorney and the prosecutor on the record were in agreement that this was a deportable offense and that Mr. Hernandez was going to be deported. Is that something we should consider in our analysis of substantial compliance? I mean, given the fact the judge did not give the advisement, he remained silent after the prosecutor and defense attorney placed upon record that this man was going to be deported. So the question is, can we consider that substantial compliance?
My answer would be no, Your Honor. And just to make clear, our argument is that substantial compliance does not apply in this case because there is no compliance. So the substantial compliance analysis does not kick in where the record is devoid of any advisement or personal exchange with the defendant regarding the immigration consequences.
Is it your position that, let's say this particular defendant knew within 6 months that he had not been properly advised and that was required, and he and his attorney knew that? Is it your position that they could sit on that for the next 20 years and still have a right to withdraw the guilty plea?
If there were evidence that a defendant knew within 6 months, I think that would be a different inquiry. However, again, the law specifically from State v. Yanez, which was recognized by the Supreme Court in State v. Francis, is that timeliness and prejudice to the state are not factors when no warning was given and there was no compliance with the statute. And to go back to Judge Winkler's question, yes, the record indicates that both defense counsel and the state made representations to the court regarding the possible immigration deportation consequences of conviction. However, there was no personal exchange with the defendant, and the statute places the obligation on the court, not on defense counsel, not on the state. The court is required by the statute to personally address the defendant and provide the advisal. And there was none. There was no compliance here. The trial court, as Judge Winkler said, ignored that issue each time it was brought up and never asked Mr. Hernandez if he was a U.S. citizen.
Well, now the plea form, though, that the judge had in front of him did have the box checked that he was not a citizen, correct? So presumably the judge knew that he was not a citizen.
Correct. And that is all the more reason that the trial court was obligated to personally address him as to the issue of his not being a citizen and facing possible immigration-related consequences. As to the advisement that was provided in writing, this court has held in another case, State v. Gully, that putting the advisement in writing is not enough. It does not satisfy the personal exchange requirement. State v. Gully involved a different issue, and that was possible sentencing consequences after a guilty plea, but it specifically referred to the statute here, 2943-031, and stated that putting the advisement in writing is not enough. Written statements do not satisfy the requirement or fulfill the General Assembly's intent to facilitate a more accurate determination of the voluntariness of a plea. Written statements aren't enough. I would also go back to this court's precedent in State v. Yanez. This court found that where the 4 requirements are met, the trial court has no discretion and must allow a defendant to withdraw his plea. And in State v. Francis, the Supreme Court recognized this court's decision in State v. Yanez. And that's in paragraph 34 of State v. Francis. The Supreme Court said some courts have found that when the defendant satisfies the provision of subsection D, a trial court has no discretion to deny the motion. State v. Yanez. And then it went further to say the exercise of discretion we discuss in Francis applies to the trial court's discretion on whether the subsection D elements have been established, not generally to the trial court's discretion once those statutory provisions have been met. So I actually believe that the Supreme Court recognized and endorsed this court's precedent in State v. Yanez, and this court nor the Supreme Court has departed from that. In any other case, we have had some compliance and the substantial compliance doctrine has kicked in. But in cases where no version of the warning was given, this court has consistently said the plea must be withdrawn.
Has this court said that after Francis? I mean, that's getting back to kind of my question and even Judge Meyer's question. Francis imposes a timeliness requirement. So let's say we agree with you and all 4 factors are met. There's still a timeliness requirement under Francis. And it does go back to Judge Meyer's question where, what if we have this particular situation and there's evidence that your client knew within 6 months about the immigration consequences and then wait? Are you saying that he can then wait 20 years? That timeliness is not even a factor that we consider because the statute says what it says?
To answer your first question, Your Honor, yes, this court has applied the rule since State v. Francis, most recently in State v. Kona in 2016. In that case, the defendant entered a guilty plea in writing, and the trial court accepted his plea in his absence. So
that's the Ohio Supreme Court,
that
right?
was the Ohio Supreme Court,
Okay.
yes. And so the Supreme Court said that they only considered whether the factors were met. And once met, the Supreme Court held that the conviction must be set aside and guilty plea withdrawn.
Did Kona overrule Francis?
No, it did not. And because there are different facts, there was no personal exchange in Kona, whereas there was in Francis. And in Francis is where the substantial compliance doctrine kicked in.
And you are at your time, but I have one more question for you before we let you go. I'm sorry, I just got distracted there for a minute. Well, I'm sorry. That buzzing kind of lost my question. I will come back to you and ask it when you come back, but you are at your time. Mr. Cummins, you have 15 minutes.
Thank you, Your Honor. Your Honor, I think both parties agreed that the elements were met under the statute. I don't think there's any dispute about that. What we have is a case where, despite that, the trial court denied the motion to set aside the plea. And this court has to look to the record to see if there's any justification for the court doing that. And in this case, there are 2 that are very apparent. The first one is the timeliness factor. This was 21 years after the plea. It's clearly untimely. Many courts have found that a lot fewer years than 21 is sufficient to find something to be untimely. So on the face of it, this is clearly untimely, and many courts have held that timeliness is a factor to consider irrespective of whether or not there were any warnings given at all. So the timeliness is a factor that must be met here, and I think it clearly is not. that alone justifies the trial court's denial of the motion to set this
But
plea aside.
what about the Kona case though? Because, you know, in reading that case, they go through and they find that all four factors are met, and then they order that the lower court allow the defendant to withdraw his guilty plea. I mean, I understand that was a diversion scenario, but they don't even discuss timeliness in that case. So how do you reconcile that with the Francis case?
I don't, I agree that Coma is different in the sense that it was a diversion case, not a plea case. But I also think there wasn't an issue of a big delay in the timing of it as well. Was there? It was a lot more.
No, it was like 2 years, but I think the way that the case concludes is they simply say the four factors are met, therefore defendant should be allowed to withdraw his plea. And there's no discussion of this extra element of timeliness in that case. It's like they just forgot about that from Francis. So I'm wondering how you reconcile the two.
Well, I reconcile it this way. The court in Francis said that timeliness is going to be something to be evaluated on a case per case basis. In some cases, it's going to be a stunningly important factor like it is here. And perhaps in other cases like Kona, it's not a big deal. So I think that it's easily reconcilable. When it's an issue, it's addressed. When you've got a 21-year delay, that is certainly something that can be looked at and addressed, and it can be determinative in a case like this. But I want to make a second point. Timeliness is one justification for the trial court's denial. The second justification is a defendant cannot show prejudice on this record. And the Supreme Court in Francis did say that to prevail on this type of claim, the defendant has to show prejudice, and he can't do that here. And the reason I say that is because the record is clear that under the totality of circumstances, this defendant knew the implications of his plea from day one. The trial court didn't give the advisement. That is clearly the case. So I don't think this is a substantial compliance case at all. I don't think the trial court complied, but it still remains that the defendant has to show prejudice, and he can't do that here. And he can't do that because on the day of the plea, his defense attorney was talking about deportation. The prosecutor was talking about the fact we're dismissing the sexual predator spec because he's going to be deported when he gets out. He was given a form to sign when he went to the ODC that says the detainer's been placed, and he's received letters and correspondence for years after this talking about deportation consequences. So just looking at the record casually, the circumstances clearly indicate that this man was aware from day one that deportation was an issue. So he can't show prejudice here. So the trial court below was right. He didn't show prejudice, and it was untimely. And for either of those two reasons, I think this decision should be affirmed. Now, if this court's concerned about the rationale that the trial court actually used, I suppose the court could remand it back to the trial court and make clear for this court exactly why it did what it did. I don't think
that was going to be my question, because the court simply says denied.
Correct.
And we're under an abuse of discretion standard, right?
Correct.
So, I mean, how do we know exactly why this was denied?
Well, you don't know exactly, but the case law is clear that sometimes it's just apparent from the record why the trial court did what it did, or whether or not the trial court was justified in doing what it did. And that's my submission to this court. It's clear from the record that the trial court was correct on two grounds: timeliness and lack of prejudice. So I think this court can call it from where it sits right now and say, you know what, there's enough on the record before the trial court that supports what the trial court did. And we can't find abuse of discretion under these circumstances. That would be what I would answer that, or how I would answer that. I have nothing to add unless this court has any specific questions. I don't think it's a substantial compliance case though, Your Honors, because I don't think the trial court said anything to him at the time. So I think that's kind of a red herring issue. I think this is clearly a case that was decided on the timeliness factor and the lack of prejudice grounds.
And just maybe this is going to be stupid once I get it out, but when I look at the prejudice piece because we have two pieces of prejudice. We've got prejudice to the state, and that's kind of part of the timeliness issue.
Correct.
And then prejudice to the defendant, which my understanding of prejudice was is it going to lead to adverse immigration consequences? And you're saying, well, he didn't show prejudice because he knew at the time of the plea hearing that he was going to be deported. But isn't that the issue in this case is when he truly understood his adverse immigration consequences, which goes to timeliness?
Well, I think the analysis has to be under the circumstances. Has he shown that if he had known this, he wouldn't have made the plea? He has to show that had he known this on the day of the plea, he wouldn't have made the plea. That's how he demonstrates prejudice in these types of cases. Here, he can't make that claim credibly because at the plea itself, you had the prosecutor and his own attorney standing next to him talking about how he's going to be deported. So he has no credibility when he comes before this court claiming he wouldn't have entered the plea had he known. He knew. He was standing right there. He heard all these discussions. If we're going to indulge the fiction that he understood all the criminal Rule 11 plea requirements because he's standing there listening, the same must be said about the discussion all around him. He heard all this. He knew about it.
But Mr. Cummings, that leads me to a question. If this were a case where strict compliance is required for constitutional rights, for the defendant to be personally notified by the judge of those constitutional rights, and in
Correct.
those cases, if he isn't, and if he says, I would not have entered the plea if I had known of X constitutional right, then wouldn't we be required to say he's entitled to withdraw his plea because it wasn't knowingly, intelligently, and voluntarily made? Isn't this the same sort of thing with strict compliance, that it, and maybe the missing piece is he hasn't said I would not have entered the plea had I not known, but isn't it kind of the same thing? That we don't go beyond that? If he wasn't told of his constitutional rights, that ends the inquiry.
Well, the way you frame that, if this was a constitutional right and it was a strict compliance standard, he would be entitled to withdraw his plea, yes. But I think that's not the case we have here before us. This is a non-constitutional right. It's to be analyzed under the substantial compliance framework. But I guess what I'm saying is I feel that's even a red herring here because I don't think there was any compliance at all. I don't really think that the state can argue credibly that the trial court complied in any way with this statute. That's not what we're arguing here. What we're arguing here is that the Ohio Supreme Court has said that there's a timeliness factor and there's a prejudice factor that the defendant must show. And on both of these grounds, forget the statutory compliance. The trial court didn't comply with the statute. But based upon the other two factors, the Supreme Court says that this court has to consider, defendant's claim fails. The trial court was right on both of those grounds. And that's the state's position.
Let me ask you this question. So under what you're saying about prejudice to the defendant, if we have the same exact facts as in this case, so he shows up at his plea hearing, his defense lawyer mentions something about he could be deported, the prosecution mentions something about that he could be deported, judge does not address him. So same exact facts, but 6 months later, he moves to withdraw his plea. Does he lose on prejudice?
Yes, I would certainly be here making that argument. Yes. I don't think I would not have a good timeliness argument as much as I do for 21 years, but I do think I would say he's standing there, he's hearing all this. He credibly cannot tell the court he didn't know. Yes, I would still say it would fail because he didn't show prejudice. Yes.
Okay.
I have nothing further, Your Honor.
All right, thank you, Mr. Cumming.
Mhm.
Ms. Larkay, you have 3 minutes left.
Thank you. I do want to first address a question that I was not able to answer yet, and that was, can a defendant who knows the consequences at the time or at 6 months later then wait 20 years? And I would say under the plain language of the statute, yes, but that is not the case here. There is no record that Mr. Hernandez understood the possible immigration consequences because of the lack of the trial court's personal exchange. Without reading the verbatim language, the trial court could have said when defense counsel or the state, mentioned deportation, Mr. Hernandez, do you understand what counsel just said? You may be deported. There were opportunities, and the trial court simply did not ever personally exchange with Mr. Hernandez to make sure he understood those consequences.
But his lawyer on the record talks about that he's going to get deported. And the prosecution on the record discusses the fact that he's going to be deported. I mean, this is a rape case. It's a very serious offense. And how can you credibly say that he had no idea about the immigration consequences based on the record that we have?
I think the personal exchange is what is missing here. Again, both counsel for the defendant and for the state made representations to the court, but neither of them made representations to Mr. Hernandez. And the trial court did not personally address Mr. Hernandez and say, do you understand that? Now, for all of the other criminal rule 11 requirements, the trial court addressed the defendant and said, do you understand this? Are you, satisfied with this agreement? And the personal exchange is what is missing here.
But then later on, I mean, you have all of the evidence about his parole hearings, and there's constantly information about how there's an immigration detainer on him. So wouldn't he at that point, once there's an immigration detainer, know that he's got some problems?
Well, as recently as 2016, I believe it was, the parole board indicated that he wasn't going to be deported. So it's not clear that over these 20 years, he has been aware of his certain deportation upon conviction of this offense.
Does it have to be that he's aware that he's going to be absolutely deported, or does he just have to be aware that he could be deported?
Under the statute, the language just says you may be deported.
Right.
But the parole board represented to him in recent years that he would not, and they did not believe that he would be deported. And so, that affected their decisions on whether to grant parole.
And what was it that caused him to now realize and to bring this request to the trial court?
My advice. I reviewed the record of his case actually on a different issue.
I'm not asking you to disclose anything that you said to your client. So that
Correct.
let's stop there.
Yes,
I wondered if there was something in our record.
Of
Okay.
immigration counsel, yes.
All right.
And that is in the record. Exhibit B attached to the motion does indicate that it was not until he consulted with immigration counsel that he was aware of this, and that was in 2019.
Didn't
Okay.
he wait, like after consultation with counsel, he waited another 3 years to file the motion?
No, we only discussed this in 2019, and any delay, which would have been maybe months, was because he was in prison over an hour away. So
I misunderstood the record. I thought that he discovered the immigration consequences in 2016 and then didn't file a motion to withdraw until 2019.
2016 is when the parole board most recently indicated that he would not be deported. And then
So is that what you're indicating is when he learned about the immigration consequences of his plea? Was in 2016?
No, it would be 2019 when he consulted with immigration counsel, and we reviewed the record and informed him of the consequences.
And is there an affidavit to that regard in the file?
Yes, it is.
He did-
Exhibit B attached to his motion.
Okay.
And
Ms. Arcade, you are at your time if you want to wrap up.
the only other point that I would like to make in this case is that Mr. Hernandez did have a co-defendant who brought the same motion on the same grounds, I believe 1 or 2 years prior to Mr. Hernandez, and both the state and the trial court agreed that vacation of the conviction and withdrawal of the plea was mandatory. So in this case, we have contradictory outcomes.
Was this the same judge?
Yes.
Okay.
So to let this stand would to allow contradictory outcomes in separate but the same case.
All right, and you are at your time, Ms. Arcade. Thank you very much.
Thank you.
Counsel, thank you for your arguments this morning. We will take the case under advisement and give you a timely written opinion. And this will conclude the arguments for the First District Court of Appeals today. Thank you.
Thank you, Your Honor.